Hello student, welcome in 𝐼𝐸 Academy. Myself Tushar Shukla. We are going to start a third part of fundamental rights, and today we will start with the freedom of religion in India. That starts with the Article 25 of the Indian Constitution. It is very important from exams point of view, from both prelims as well as in mains perspective. So we will see what Article 25 talks about. Let's start with the Article 25. Article 25 says that freedom of conscience and free profession, practice, propagation of religion. What it talks about? It talks about freedom of conscience, free of profession, practice, propagation of religion. These are main terminology of this Article 25. Now we will see what do we mean by these terms. First is conscience. There is freedom of conscience. It means that you are free to follow whatever belief or thought system you believe in that system. For instance, you believe that there is a God. Some other may be believing that there is no God. So every person has a right to think about in whatever way, in whatever manner they want to. It is covered in a conscience. Second part is practice. Freedom to practice. In India, every religion has a freedom to practice their religion of their faith in whatever manner they want to be. For example, you want to worship in different ways. For in evening you want to do, in morning you want to do, or at any time you want to do. So in this regard, there will be no regulation or no interference by state government, state and any other private individual. It is covered under Article 25. Now we will talk about profess. It means that, for instance, I am from Hindu religion, so I can profess it, propagate it in the different religion, whatever manner we want, until it doesn't hurt the fundamental rights or fundamental sphere of other individual. Up to that level, we are allowed. And there is third word also, propagation. For instance, if we want to promote our religion in different part of our country as well as in other countries, so in that regard, we are allowed to do so. For instance, must have seen that people who belong to the 𝐮𝐸 temple, you will find them at several places. They were displaying their religious textbooks, why people should join them. They are spreading their idea so that more and more people can join their movement. It is also covered under Article 25 of Indian Constitution. We have seen that what is the main crux of Article 25. That is to freedom of conscience, that every person has a freedom of conscience, profession, practice and propagation of their religion. But there are certain limitations are also imposed over this right. And what would be the criteria for imposing restriction? That will be, these are subject to public order, health, morality. For example, let's talk about public order, which is the main issue in that. For example, you have listened about the recent issue of namaz at several places. which were being offered at public places, or even at sometimes they were often offered at the highways and roads. So many people complain that it is against the public order because it is creating disturbance for the common people. So on that ground, public order, certain 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 right up to a certain extent it can be curbed. For example, there are many cases when it has been found that people are being converted into another religion on the basis of money and muscle power. So that is also against the public order. So in this regard, state can take action. Okay. Now talk of morality. In every religion, there are certain elements which are not relevant in the context of present time. So the modern people who are like intellectual person are opposed to those activities of every religion. For example, triple talaq. It was followed by the people of Islamic religion in India. What government did? It banned it because it was considered as against the rights of women and against the morality of the society. Similarly, there are a lot of activities which goes against the health of a person or health of a society. In that regard also, this right can be curbed. Now let's move to further. The further provision of this article says that this provision gives that state can make laws. What says? Article 25 gives power to state to make laws to regulate and restrict any financial, economic, political, secular activities associated with the religious practice. In the last few sessions, we have discussed about the principle of secularism in India and in the western part. In India, the principle of secularism is that every religion is equal in front of a state, and state can interfere in religious matter to ensure the social justice, and that power is given to state under Article 25, which gives power to make provision to states regarding different matters. For example, financial, economic, political and secular activities. What is the next thing? This provides for social welfare and reform that we have talked about under the principle of secularism. Hindu religious institute of a public character, all section and classes of Hindus. Next important thing is in this article is that Hindus are constructed including the Sikh, Jain, Buddhist religion. This provision says that Hindu is a broader term or an umbrella term, and that will include the other religion which were formed from the Hinduism only, such as Sikh, Jain, Buddhist. These are included as a part of Hinduism in the Constitution of India. Let's move toward next point. One next provision of this article says that people of Sikh faith who are following the Sikhism, wearing and carrying the kirpan. It is a small sword that women and men used to carry, will be considered as included in the profession of Sikh. Means they can carry weapon. It is provided under this article, article number 25. Now we will talk about article number 26. What article number 26 says? That freedom to manage religious affairs. Freedom to manage religious affairs. In the article 25, we seen that talks about individual. But here It talks about organization, you can say, forsake. The main provision of this article is that this article provides every religious denomination different rights which are subject to morality, health and public order. First of all, what are religious denominations? For example, in Hinduism, there are different mats which are established by different sampradaya in a different part of country. So they are considered as a denomination under the Hindu religion. Denomination under the Hindu religion. So these denominations are given certain rights. Which right are? Right to form and maintain institution for religious and charitable intents. Right to manage its own affairs in the matters of religion. Right to acquire the immovable and movable property. Right to administer such property according to the law. There is not a lot to explain in this article. You have to only understand that religious denomination of every religion are given certain rights under Article 26 of Indian Constitution. Okay? I hope everything is clear. And those who are watching this session, I am requesting them to please share and subscribe this channel so that other people can also enjoy my lectures and get good knowledge for their exams. Next, now moving to our next article, that is 27. Now what Article 27 talks about? The main provision of Article 27 is that freedom as to payment of taxes for promotion of any particular religion. In simple word, it says that state cannot impose any taxes or can take any payment or revenue from any people of this country to promote any particular religion, which means state will be not biased toward any religion. It will have a equalized or equal treatment with every person. For example, the rupees of taxation cannot be used for constructing temples or promoting any religions, promoting the Islamic religion or promoting Sikhism in India. This is covered under Article 27, and it is one of the mainstay or the pillar of secularism in India, that for state every religion is equal. Let's see the main content of this article. There cannot be no taxes, proceeds of which are directly used for promotion or maintenance of particular religion or religious denomination. So what we in simple word, I have explained you that state cannot use money, that is taxpayers' money, for promoting any religious activities in India. It is under the Article 27 of your constitution. One more thing, in exam, if the question is from Article 26, 27, 28, generally I have seen lot of students get confused in what things are covered in Article 27, what things are covered in 26, what things are covered in 28. So you have to make differences or understand them in such a way that they do not create any confusion during exam time. Okay? Now it's Article 28, and it is the last article of right to freedom of religion in India under the part 3rd of the Indian Constitution. So what is covered in this article, or what freedom it gives to the people of India? Let's see. Article 28 says that freedom as to attendance at religious instruction or religious worship in certain educational institution. Now my first question to you guys is that in India, Is there people have a institution, education institution have a freedom to give any religious instruction? For example, if you go to a school, your school says sing Gayatri Mantra or sing any verses of Quran. Is that possible or not? So this article deals with those cases. It gives different situations in which conditions religious instruction can be given and in which situation religious instruction cannot be given. For example, if we talk about any institution that is run and governed by the state, in that institution religious instruction cannot be given because it is run by a state and it is a secular institution. And on the other hand, there are different institutions which are aided or that fund is given to them by the state. In those institutions also, it is not possible that religious instructions are being given over there. Next come, there are certain institutions which are established by the trust or any religious institution. They are being run by the government. For instance, if they are being, so in that institution, religious instructions are allowed, but students cannot be enforced to follow those restrictions. It is a freedom for students whether they want to follow or not follow. And also, there is need to take permission from parents. So we have seen in different institutions, for example, if there is a government institution, religious instruction will be not allowed. If there is the college or institution is aided by the government, then also religious instruction will be not allowed. Third, if it is being run by any religious institution, then they have a right to give religious instruction because it is run by particular religious denominations and they have a certain objective that is related with the religion only. So in such institution, religious instructions are being allowed under this article. Quickly we will see the provision of this article so that you guys get more clarity. This article permits educational institutions that are maintained by the religious groups to disseminate religious instructions. Means institutions which are being established by the religious denominations, in that institution religious instructions are possible, can be given. In this article, similar things are talked that we have covered till now. For instance, it provides that no religious instruction shall be provided in a state-run education institution. Means institutions which are being run by state, their religious instruction cannot be given. Next is educational institution administered by the state that were established under any endowment or trust which requires that religious instruction shall be imparted, that we have talked about recently. Such institutions are exempted from the above clause, that no religious instruction shall be provided. In such institute, religious instruction can be given to the students. Now what next provision says that any person attends or any educational institution that is recognized by the state or receiving state aid shall not be required to participate in any religious instruction that may be imparted in such institution. That this directive is given by this provision of Article 28. Now we have covered 4 articles of right to freedom of religion in India. That is 25, 26, 27 and 28. Now we are starting with the article 29, and in this article we will see that it talked about protection of interest of minorities. In India we see that Hinduism is a major religion and there are different religious minorities in India. But here the word minority is not defined in Indian constitution. It can be interpreted in the context of linguistic, religion, cultural, whatever minorities it could be. All are given, or interest of those minorities are covered under this article. So the first provision of this article says, state the citizen of India who are reside having a distinct culture, means they have a unique culture, language and script, shall have a right to conserve their culture and language. For example, Parsis, they are minorities. There are certain, for example, certain tribal groups which has a distinct language from the mainstream society. They are allowed to preserve, conserve their culture and languages. It is given to them under Article 29(1). Next thing is that the right is absolute, having no exception. There cannot be any reasonable restriction on this right. In other rights, for example, under Article 19 or in that freedom of religion, we have seen that there are reasonable restrictions being imposed by state, that these rights are not absolute in nature. But this right for the conservation, preservation of that cultural element of minorities or interest of minorities, there is no reasonable restrictions imposed over them. Next in Article 29(2) talks about admission to the educational institution cannot be denied based on race, religion, caste, language, etc. If it is a state institution, an institution funded by the state aid, this individual right cannot be a community right. In a simple word, if I say, for example, you speak Hindi and you go in a South Indian college or institution, then they not deny your admission on the basis that you speak Hindi. Or if you are from Punjab, you speak Punjabi language, that is Gurmukhi, anyone in UP cannot deny that it is on the basis of your religion or on the basis of your language, we will not take your admission. This protection is provided under Article 29(2). I think both the provisions are clear now. Now we will talk about Article 30. It is also important like Article 29. What Article 30 says? It talks about right of minorities to establish and administer educational institution. For example, people of 𝐼𝐸 tribe in northeastern part of India, if they want to establish any institution for the promotion of their culture, language, tradition, anything, then they are allowed to establish it under which article of Indian Constitution? That is Article 30 of Indian Constitution. Let's see the provision of this article. Article 31 says that it provides for all religious and linguistic minorities the right to establish and administer educational institution of their choice. It is available to religious linguistic minorities only. So you have to remember that it is available only to religious and linguistic minorities only. No other minorities are given this right. For example, you must have listened about the madrasas. They are being established under this article, and they have a freedom or power derived from this part of Indian Constitution. Now moving to the next provision, 32. What it says? It says that it provides, while granting the aid to the educational institution, the state cannot discriminate on the ground that a particular institution is administered by a religious or linguistic group. What it says? If a state has to provide a aid to an institution, it will not matter for them whether it is run by any religious or linguistic minorities. So these things are being covered under this part 32 of fundamental rights. Now it's about Article 31. In the original Constitution of India, Article 31 was related with the right to property to people. And this article was repealed through the 44th Amendment, year the 1978, and it was inserted as a constitutional right under Article 300A. Under Article 300, so Article 31 was repealed, and which earlier dealt with the fundamental right of property in India, and it was transformed into a constitutional right. However, through the first constitutional amendment and different constitutional amendment act, different sub-part of Article 31 was added as we moved forward in the independent India. For example, 31A, what it says, it talks about, it says 5 categories of law from being challenged and invalidated on the grounds of contravention of fundamental rights conferred by Article 14 and Article 19. I will discuss about the little background also. During British era, certain people of certain background, for example Jamidars, businessmen, were given preference over the common people, as a result of which large scale inequality was existed. So after independence, government wanted to carry out land reform so that there could be an equal distribution of resources in the country. In that scenario, the fundamental right to equality and right to freedom was given to every citizen. And those people who were rich, they were against the land reforms, that it will give special privilege to people who do not have a resources. So these two articles were acting as an impediment. So this article was inserted that judiciary cannot, certain acts cannot be challenged in judiciary on the basis of violation of Article 14 and 19. Moreover, there were certain acts enacted to implement the DPSP, Directive Principles of State Policy, that will covered in our coming lectures. Then you will have a more clarity, which are instructions given to state for the socio-economic development of the society. So when there was a conflict, so this article was enacted so that the acts which violate the Article 14 and 19 for the broader welfare of the society could not be challenged in court. So what acts were included in this article? They were acquisition of estates, related right property by state, taking over the management of properties by the state, It talks about nationalization, amalgamation of corporation, extinguishing modification of rights of directors and shareholders of the corporation. This thing you have to remember. For the social justice, this act was inserted in the Indian Constitution. For the social justice, you have to use the term social justice here. The next few things which were added in this article were extinguishment or modification of mining leases. Means mining leases will be decided by the government of India. It also provides the guaranteed right to compensation in cases of acquisition or requisition of the private property by the state. What we earlier taught, for the social justice, government can take different steps. It can even acquire the private property of the individual, as a result of which they were going into courts so that their right is not taken away, their right to property is not taken away. So in this regard, this act was inserted in the Indian Constitution so that the principle of DPSP can be achieved in the country. Next is Article 31B. It was also added through the amendment in the Indian Constitution later on, along with the 31A, by the first Constitution only in the year 1951. What it says? It protects the acts and regulation included in the 9th schedule from being challenged and invalidated on the ground of contravention of fundamental rights. So Article 31A and 31B are quite similar. In Article 31A, they talks about mainly 5 acts, 5 provisions. But here, the act which are included in a 9th schedule, that were added through the first constitutional amendment in the year 1951. So it has a wider application. In comparison to 31A of the Indian Constitution. I hope everything is clear. When this act was enacted, there was another thing, that it imposed certain restrictions on judiciary, that this act cannot be challenged in front of judiciary on the basis of contravention of fundamental rights. And you already know that Indian judiciary is quite active. It is different from the judiciary of other countries. So what it did? So what it did in the 𝐼𝐨𝐥𝐸 case, what Supreme Court says that ruled that even the laws in the 9th schedule would be open for scrutiny if they violated fundamental rights or the basic structure of the Constitution. Basic structure we will discuss in a coming sessions. In this case, the sanctity of Article 31B was removed, which says that certain acts which are kept under the 9th schedule cannot be challenged in courts. But in this case, you have to remember the name of this case in the year 2007. That Supreme Court, such cases can be also challenged in Supreme Court. So it was given under this act. And this was all about 31B. Now we will talk about the third act, 31C. We have seen 31A, what it talks about, 5 acts, 5 categories. 31B talks about acts which are inserted under 9th schedule of the Indian Constitution. Now what 31C says? It says that no law that seeks to implement socialist directive principles specified in Article 39B or 39C shall be declared void on the ground of contravention of fundamental rights conferred by Article 14 or 19. It is quite similar to Article 31A and 31B. If the DPSP, that is Article 39B and C, which deals with the inequality or the resources distribution in the society, if for that act has been enacted that there will be a resource distribution or similar acts are passed, so such act cannot be challenged in judiciary if they violate Article 14 and 19 of the Indian Constitution. So it was given by the Article 13C of the Indian Constitution. Next provision is no law containing a declaration that it is for the giving effect to such policy shall be questioned by any court on the ground that it does not give effect to such a policy. It also says same thing, that it cannot be questioned in the court. It cannot be questioned in the court. So we have seen Article 31A, 31B, 31C of the Indian Constitution. Now we will talk about Article 32. Article 32 talks about constitutional remedy. What do you mean by constitutional remedy? For example, you have a right to freedom of thought, speech and expression, freedom to assembly, freedom for movement. If anyone is violating or curbing that right, that you cannot enjoy that right, then what you will do? Will go to Supreme Court for constitutional remedy to get the remedy of that violation that your fundamental right has faced. So what will be there? Constitutional remedy. So there will be a constitutional remedy. And this Article 32, Supreme Court is empowered. Supreme Court is empowered to give directive for the restoration of fundamental rights. On the other hand, High Court is empowered under Article 226 of Indian Constitution. Both of have certain different. For example, Supreme Court can deal with the only fundamental rights, but High Court under this Constitution article deals with the both fundamental articles and other articles which are enshrined in the Indian Constitution. Here it can take suo motu cognizance. It cannot. Okay. Here you have to file a complaint. Next thing, it cannot deny any remedy if the right is violated, but it has a right to deny even the right is violated. So these are major differences. In prelims, there is a straightforward question on code-wise question is there on this writ jurisdiction of Supreme Court and High Court, and this question can also be asked in mains examinations. So I've discussed about the constitutional remedy of Article 32 and Article 226. But Article 226 we will discuss also later on. One more thing. According to the father of Indian Constitution, that is B.R. Ambedkar, Article 32 is the one of the most important article of Indian Constitution, according to him. And there is a triangle which contains three important provisions of Indian Constitution. That is 14, 19 and 32. And in middle, Article 21 is placed. So this is the main crux of fundamental rights, most important fundamental rights of Indian Constitution. And Article 32 provides different writ jurisdiction to Supreme Court, so that it will be easy for it to restore the fundamental rights of the people. And there are mainly 5 writs in Indian Constitution. For example, we are not going to discuss them in deep, because that will be covering in the chapter of judiciary under the writ jurisdiction of Supreme Court. For example, writ jurisdiction include habeas corpus, mandamus, certiorari, prohibition, and one more writ jurisdiction is there. These are covered under Article 32 of the Indian Constitution, covered under Article 32 of the Indian Constitution. Okay, but we will discuss these 5 writ jurisdiction when we are dealing with the chapter of judiciary, where we will discuss about the writ jurisdiction power of Supreme Court. So you have to keep in mind that for this session only, that there are 5 writs that Supreme Court issue under Article 32 for the restoration of fundamental rights of the people. That is covered under Article 32 of the Indian Constitution. Now we will talk about Article 33 of Indian Constitution. What Article 33 deals about? What Article 33 deals about? It empowers the Parliament to restrict the or abrogate the fundamental rights of members of armed forces, parliamentary forces, police forces, intelligence agencies, and other forces. For example, we all have a different right. For example, right to movement, freedom of speech and expression. But there are certain categories of institutions in India, such as armed forces, parliamentary forces. They do not have a fundamental rights like all other we enjoy. And these rights are curbed by the parliament, or it can restrict their rights. You know what is the objective behind it is to ensure the proper discharge of their duties and the maintenance of discipline among them. It is directly related with the security of the nation. So for the broader perspective, that is maintaining security and unity and integrity of the country, there are certain categories of people whose fundamental right can be restricted. They cannot have a fundamental rights similar to the other person. Okay, that is covered under Article 33 of the Indian Constitution. I hope everything is clear, and those who are watching this lecture, please share and subscribe our channel, and also click bell icon so that you can get a notification as early as possible when our videos are being uploaded. Next is Article 34. It is the second last article of Indian for in the part 3rd of the Indian Constitution. That is Article 34. Now we will see what Article 34 talks about. It says that it provides for the restrictions on fundamental right while martial law is in force in any area in the territory of India. Most of you will be not aware about the what martial law is in India because it's rarely not implemented in India. We do not find it that martial law is imposed in some part of a country. That's why you have a very less knowledge about it. I will tell you about it. As per this provision, martial law has not been defined anywhere in the constitution, but literally means military rule. So there is no any exact definition of martial law in India. For example, in certain region, if we find that, for example, if riots are happened in any part of Indian territory, or there is a violence in that area, turbulence in that area, then military is being imposed over there. For example, CRPF, Rapid Action Forces are being deployed in that area. So they have a right to bring peace in whatever manner is possible. So that can be considered a type of military rule. In that military rule, fundamental right of peoples can be curbed. For example, there is a chances that if people come out of different communities, violence may grow. So in that area, freedom that rights of people can be curbed, that you have to stay within their homes until the peace is not prevailed in that area. So it is given under Article 34 of the Indian Constitution. Under which article? Article 34 of the Indian Constitution. So in exam, if the question comes under which under which article of Indian Constitution martial law is mentioned, or which says that fundamental rights will be restricted during the martial law, then what will be the answer? Answer will be the Article 34 of the Indian Constitution. Which answer will be there? Article 34 of Indian Constitution. Let's see the another provision of this article. It says that martial law imposed under extraordinary circumstances like war, invasion, insurrection, rebellion, riots that we talked about right now, or in any violent resistance. So in these cases, martial law can be imposed in the country. So in these cases, martial law can be imposed in the country. Article 34 empowers the Parliament to indemnify, compensate any government servant or any other person for any act done by him in connection with the maintenance or restoration of order in area where the martial law was in force. This provision of Article 34 gives power to the Parliament to compensate any officer or person who has helped in the promotion of peace or bringing normalcy in the area which was impacted by where problem was raised. So it was about Article 34. Now the last but not least, Article 35 of the Indian Constitution. It is the last article of part 3rd, that is fundamental right, with which we are dealing today. So what Article 35 says? You have to understand in a deep Article 35 says that uh, sorry, it lays down that power to make laws to give effect to certain provisions, fundamental rights shall vest only in the hand of Parliament, not in the state legislature. For example, Article 21, Article 19, Article 14, Article 18, Article 17, these all fundamental rights. If they have to implement it through the laws enacted by the Parliament. So the Parliament has the only authority to do such things. State legislature do not have such authority to make laws related with the fundamental right. I hope this article is clear. It says that in order to give effect to the fundamental rights or any provision in that regard, so power is in the hand of Parliament and the state legislature do not have a such right. Now I hope everything is clear about Article 35 of the Indian Constitution. So in this regard, we have completed the part 3rd of the Indian Constitution, that is fundamental rights. Now in the next session, we will start with the DPSP. That is in the part 4 of the Indian Constitution. Thank you guys for watching this session. I hope you like this session and please give more suggestion in the comment section so that I can bring changes in my teaching style or content presentation according to your will. Okay, it was all about this session and please share and subscribe this channel. Thank you and have a nice day.